can now move to our final speaker in the session, Victor Kabata, who's a postdoctoral research fellow at Sorbonne University in Abu Dhabi. Thank you so much for joining us, Victor. I understand you've had a little bit of Wi-Fi issue, so hopefully the Wi-Fi will be pretty resilient and robust. You're going to talk to us about the assessment of the legal and regulatory framework supporting the establishment and implementation of the National Integrated Identity Management System in Kenya. So look forward to hearing from you on this. Over to you, Victor.
Thank you so much for the welcome, and sorry I had a few technical issues. So basically, my presentation seeks to, provide an overview of the legal and regulatory framework that is required for establishment and operational or implementation of an identity management system. So I'm going to present the various elements that make up or that form a supportive, legal framework for the establishment and implementation of an ID system. And then I'm going to find out if those elements are actually present in Kenya, where the government has been trying to implement what we call the National Integrated Identity Management System. So basically, that's what the presentation is all about. Lastly, I'm going to, make some recommendations regarding some of the legislative gaps that, are going to arise. So I'm going to make some recommendations, and that will be it for this presentation. Next slide, please. So just to provide a background, one of the things that we are seeing here is that an analysis of existing literature indicates that before any country or jurisdiction seeks to implement a digital ID system, there's need to conduct an assessment. So there's need to conduct an assessment just to establish the legal landscape in that particular country before they can attempt to, implement a digital ID system. So that assessment was not done as far as in Kenya, so to say. So the National Identity Integrated Identity Management System in Kenya was undertaken without an assessment being done. So this study now seeks to, fill that gap, to undertake an assessment just to find out if all the legal elements that are required were actually present in Kenya. So next slide, please. So I have 3 research questions. This study is based on 3 research questions. So one of the things, or the first research question relates to what are the elements that constitute a comprehensive legal and regulatory framework for digital ID system establishment and operation. So this is a general question. Regardless of any jurisdiction that you are in, what are these elements that are required? So then the second research question, after identifying the elements, we want to find out from the identified elements, were these elements that have been identified in research question 1, were they present in Kenya to support the study of the ID system? Then lastly, we are going to make recommendations for improvement and address the legislative gaps that will be identified. Next slide, please. So the problem statement, of course, I am saying that Kenya has implemented the National Integrated Identity Management System. The system was expected to, of course, close the identity gap in the country and also to facilitate access to government services. Of course, that has not been realized because the system was encountered some challenges. So its implementation has faced challenges to a point whereby it has suffered, a crisis in public confidence. the citizens have no confidence in the system, and that can be seen by the fact that they have not those that are registered. Majority of them have not even collected the identity cards. So only a very small fraction of those that registered collected the identity cards. This is despite the government rolling out a massive program to issue the cards. People or citizens were not willing to collect the cards. So there is that confidence crisis as far as the implementation of this system is concerned. And what we are saying is that what could be the reason for that would be the lack of an elaborate legal and legislative framework. So that is why we intend to just outline what is this legal and regulatory framework that was required before setting up of this system. So next slide, please. So, and what is the research methodology that this study has adopted? This is a qualitative study where data was collected through document review and interviews, specifically to answer research question 1, which sought to establish the general elements. And I did a literature review of issues to do with digital ID system, privacy and data protection, internationally and also in Africa. So I did a literature review. Then subsequently, to answer research question 2, I reviewed the existing literature on the NIM system. And also this the information collected from literature on this system was collaborated by interviewing the legal officer in the Ministry of Interior and Coordination of Government, which is responsible for the implementation of the NIM system in Kenya. And then I also interviewed a representative from the Office of the Data Protection Commission, which is the body that is charged with enforcement of the Data Protection Act 2019 in Kenya. So basically, that's the methodology that has been adopted. Next slide, please. So on to the findings. So for research question 1, where I was seeking to establish the general elements that are required in any jurisdiction when establishing a digital ID system. So one of the elements is there has to be a constitutional provision guaranteeing the right to privacy. Of course, a constitutional provision lays the foundation for enactment of other laws relating to data protection and also the Privacy Act and all that. So a constitutional provision enshrining the aspect of privacy is very important. Now, another element that is necessary is having an enabling law governing the establishment and operation of the ID. So for you to have to successfully implement a digital ID, you need to have an enabling law that specifically outlines the purpose of the ID, the information that this ID system is going to collect. So you need a very elaborate ID law, which will clearly outline the purpose of the digital ID system that you are intending to set up. Another element that is required is the aspect of amending law to registration of persons. The thing here is that we know that the aspect of registration of persons is a very key aspect as far as digital ID conceptualization is concerned. So if you're going to set up a digital ID, then there is need to amend the law that relates to registration of persons, so that then it can provide or it can you can broaden it to accommodate the establishment of a digital ID system. Then we also have an aspect about the presence of an authority to oversee and enforce protection of personal data. So fine, you can have the legislative framework in place, but we need a body, an institutional body to oversee the enforcement of whatever is provided by these legislative laws that we are talking about. So we are talking about, we could talk about some countries have the Office of the Data Protection Commissioner overseeing those issues. Others have a respective ministry that has been, mandated to undertake that task. But it's always important to have an authority that is overseeing the enforcement of these legislative instruments that we are talking about. Next slide, please. So other additional elements that I identified, there's need to have an existence of a law governing corruption, processing, and storage of personal information. What we know is that these ID systems are data-centric, so to say. They collect or harvest a lot of information relating to citizens. So there needs to be a very robust data protection law that is going to cover the collection, processing, and use of this data, so that then we don't have breaches or data breaches. Another element is the existence of policy and regulations to operationalize the laws. So here what we are saying is that, fine, you may have the digital ID law, like we mentioned, or even the data protection law, but you need regulations and policies to operationalize these laws or these acts that we are talking about. Without a regulation to operationalize the laws, then implementation of those laws becomes a challenge. So having regulations, having data protection policies is very key also. Then another element relates to coherence between the data protection law and other related laws, such as the freedom of access to information. So one of the things that we need to be clear about here is that the right to privacy does not operate in isolation or in a vacuum, so to say. It is related to other aspects. And here, what I have in mind is the law relating to access to information. So we need to have, if we are talking about a digital ID law or a data protection law, then it needs to be harmonized with the freedom of access to information. Otherwise, there is likely to be, conflict and also contradiction if these laws that are all relating to management of information are not harmonized. So for an ID system to work properly, then there needs to be that harmonization of those laws related to management of information. The last element is the existence of a law regulating the digital economy. And basically what I want to mention here is the ID system is a part of a broader e-commerce, or it is the digital ID system is simply part of a broader digital economy. So for this ID system to function effectively, then we have to have an overriding legislation governing the digital economy in that particular country. So when I talk about an overriding law governing the digital economy, perhaps we could talk about something like the Cyber Crimes Act, something that a law that ensures that the whole digital economy space within that country can be trusted. Because for a digital ID system to operate effectively, then there should be a trusted digital space in that particular country. So basically, the digital law, economy law is also very important. Next slide, please. So having answered research question 1, where I have identified the various elements, I want to go to the Kenyan context now, in looking at whether Kenya had, whether all these elements that we have identified, whether they were present in Kenya to support the implementation of the NIM system. So fine, first, as regarding the constitutional guarantee, the right to privacy in Kenya is explicitly provided in in the Constitution. We have Article 31 of the Constitution, which recognizes and guarantees citizens' right to privacy. Beyond that, beyond the constitutional guarantee, I would also want to mention that Kenya is signatory to various international instruments guaranteeing the right to privacy. I'm talking about the Universal Declaration of Human Rights and also the International Convention on Civil and Political Rights. So Kenya is signatory to these international instruments, which means that it is bound, or it has committed itself to uphold the right to privacy. Next slide, please. Then, as far as an enabling ID law is concerned, in Kenya's case, yes, there is the establishment of the NIM system did not follow the normal legislative channels. And I believe this is where the biggest challenge as far as implementation of this digital ID system is concerned, because when you would expect this NIM system to be established through a standalone law, that was not what was done. Instead, it was established through a miscellaneous amendment to the Registration of Persons Act. That's why I'm saying the normal legislative channels that are expected when you're establishing a digital ID were not followed in Kenya's case. So what happened is that there was a bill, a miscellaneous amendment bill that was that took place, and this through this miscellaneous amendment, that's how the NIM system was set up or was founded. So, of course, the challenge with having a miscellaneous amendment bill is that you minimize the public scrutiny of the system. So the system has not been scrutinized. There is no public participation. Of course, that has brought a lot of challenges. So other than that, there was also the regulations. The government came up with the regulations to govern or to guide the operation of the system. Of course, these regulations also had challenges in the sense that they did not elaborately outline the purpose of the system and the kind of data that was being collected by the system. So this has to be the biggest challenge that faced the implementation or establishment of the NIM system. Next slide, please. So, of course, I've said the system was formed through amendment of the Registration of Persons Act, Section 9 of the 9(1) of that Act established the National Integrity Identity Management System. So, regrettably, this Act does not specify the purpose of, does not clearly specify the purpose of the system, and also issues related to protection of personal information, as well as the kind of information that this system is going to be collecting. Of course, that explains maybe why the low public confidence in the system. Next slide, please. So as far as the existence of a law governing the collection, processing, and storage of personal data, yes, we have the Kenya Data Protection Act 2019, which is in place. It is modeled or adopts the language of the European Union's General Data Protection Regulations. So it provides or it outlines the rights of the data subject. It also outlines the obligations of the data controller as well as the data processor. So this Data Protection Act is actually in place. Next slide, please. So existence of regulations to operationalize the Digital ID law and also the Data Protection Act. So like I said, regulations have been formulated, but they are still going through the public participation stage. So we have the data protection regulations, which are being taken through the public participation stage, and then they're going to be taken to Parliament for for approval. The same case applies to the digital ID regulations. They have been formulated, but there is still the issue of public participation, which is still ongoing. Yes, continue. Next slide. So coherence between the Data Protection Act and the Freedom of Information Act, that one is in place. There is the two regulations or the two acts have been harmonized. So basically, you will see that, for example, Section 6.1 of the Freedom of Information Act outlines or clearly recognizes the Data Protection Act. So that harmonization has happened, which is very good for the operation of the digital ID system or the NIMS system in this case. Next slide, please. The presence of an oversight authority. So fine, I mentioned that there's need to have an oversight authority to oversee the enforcement of these laws that we're talking about. So in Kenya's case, we have the Office of the Data Protection Commissioner, which, as much as it is organized to be an independent office, it is very much reliant on the executive in terms of funding, in terms of the composition of the board of directors and all that. So this Office of the Data Protection Commissioner, while it is independent, it is said to be independent by name, on paper, that may not be the case practically. There is a lot of influence from the executive. The other oversight body or implementing body that is there is the Ministry of Interior and Coordination of National Government, which has been mandated to implement this system. Of course, this ministry is part of the executive. Now, what that means is that in case there are any breaches of data breaches as far as this NIM system is concerned, then it becomes very difficult to oversee or to question this ministry. So that becomes a challenge. So the next slide, I want to wind up because time is also coming to an end. So existence of a law regulating the digital economy. Yes, we have that in Kenya. We have the Computer Misuse and Cybercrimes Act 2018, which seeks to govern the digital landscape in terms of the digital economy. But we have a challenge that some of the sections of that of this act, some of the sections of this act were declared illegal by the court. Some people went to court, of course. So some of the provisions within this act are not very active because of prohibition by the court. The next slide, please. So I want to conclude. I want to make a conclusion, and in conclusion, I'm saying effective establishment and operation of a digital ID system is hanged on the existence of a supportive legislative framework. Of course, we have seen that. Although Kenya has, to a large extent, formulated a supportive legislative framework, the fact that the digital or the enabling digital ID law did not adhere to the normal legislative channels has eroded the public confidence in the NIMS system. So I'm recommending that Kenya's NIMS system should be implemented based on a trusted identity framework. Like we have such a case in Australia. So I'm proposing that Kenya should borrow such a model. The framework will outline the rules and standards that digital identity providers must adhere to, and it will also ensure safe, secure, consistent, and reliable use of the NIMS system. So I would want to end there, and I want to welcome any questions or comments. Thank you so much.
Thank you so much, Victor.